In Washington state, when parents are splitting up, either through a divorce or they've never been married and they want to figure out custody arrangements, we call it a parenting plan. Parenting plan is a court order that determines the schedule for children, the decisions about how major decisions in their life will be made and split up between the parents, and also how we're going to resolve disputes in the future when the parents don't agree on what to do for the children. A parenting plan in Washington state is supposed to last until children turn 18 years old, which can be a very long time if you have a little baby that you're determining a parenting schedule for. That's why it's really important for parents to think about the big picture and the long range decision that they have to make when they're entering into a parenting plan for their children. In Washington state, we don't use typically those terms that you hear a lot of places like custody, full custody, joint custody. The state statutes have gotten away from that type of language. And instead, what we're looking at is where are the children going to be residing? What is their schedule going to look like? Who are they going to spend every overnight with? What will be different over the summer, if anything, when it comes to the children's schedule? What will be different over holidays and special occasions like birthdays? And how are we going to handle transportation? How will the children get from one parent's house to the other? Is it going to be handled at school? Are we going to meet in the middle somewhere? Are we going to do the exchanges at each parent's home? There's a number of factors that we break down all these parenting decisions into in order to come up with a plan for how parenting is going to be handled. And the goal is to make sure that we've contemplated some of the long range things that parents are going to have to deal with when it comes to daycare, all the way through your children learning how to drive and getting their first driver's license, to dealing with their requests for dyeing their hair blue or getting piercings. We want parents to talk about these things up front and come up with a game plan. And the reason is that we know from a lot of social studies that litigation and fighting around parenting causes stress to your children. So if we can come up with a formula that takes care of how these decisions are going to be made as much as possible in advance, the better off children are likely to be. The best interest of a child is dependent on a number of factors, including their individual needs, their health, their psychology, their emotional needs, their connection to family members and siblings, the stability and consistency and routine, their educational needs, and overall developmental needs are a factor when we're deciding what is the best interest of a child in a custody or parenting plan determination. In Washington state, if you want to change a custody order, that is typically done through a parenting plan modification. It's a petition to the court to ask that the parenting plan order that's been entered for your child be changed. And it is a big burden to meet in Washington state. You need to prove that there has been a substantial change in circumstances on the face of the facts that have led to this need to open up the parenting plan and relitigate the schedule for children. There is a presumption in Washington state that the parenting plan should not be changed because we know that litigation for children usually causes stress in their household and is typically not very good for kids to be experiencing stress and inconsistency. So parents really need to prove that something significant has changed that has a negative impact on the child's best interest, and then the court will say, okay, we will talk about a updated parenting plan, but only after the adequate cause threshold is met. In Washington state, if you want to move after you've entered a parenting plan for your child, you can do so, but there are a number of procedures to take into consideration. So if you are the parent who has majority of overnights, or you've been designated as the primary parent in your parenting plan, you must give notice to the other parent following the terms of the relocation statute for parenting plans. There's really specific procedure that you must follow. And even if you're in a safety risk situation where you've experienced domestic violence, there are still particular procedures that you need to follow to make sure that you're not violating the parenting plan and you're giving adequate notice to the other parent. And then you may ask the court to modify your parenting plan if you followed the procedures for relocation notice. There is an opportunity to modify the parenting plan and come up with a new schedule given the circumstances of new locations and the geographic differences that the parents are going to be experiencing. If you have any questions about custody for your child in Washington State, just give us a call at View Ridge Law.